How do we use a transcript at trial? You want to learn how? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. We use a transcript at trial pretty much on cross-examination. Now, a transcript is nothing more than a booklet put together of questions and answers given under oath. And that typically happens either with prior trial testimony or at pretrial testimony given during the course of something called a deposition. So here's a perfect example of how we do that during cross-examination. Let's say a doctor is on the witness stand testifying for the defense. Let's say he's testified that the failure to timely recognize a hole in the bowel is not malpractice. So here's how it goes. Here's how it would go? Yeah, here's how it goes. Doctor, you've testified during the course of your direct testimony that it is your opinion that the failure to timely recognize and treat a bowel hole, a perforation, during the course of the surgery is not malpractice. True? True. And doctor, it is your opinion that this represents a known risk of this particular surgery involved in this case. True? Yes. And under no circumstance do you believe that it's possible for a surgeon to recognize this hole during the course of this particular procedure. True? Yes. And you would agree, doctor, that if in fact a doctor was able to recognize it and failed to recognize it during the course of surgery, that in your opinion that would be a departure from good and accepted care. True? True. Okay, so now the doctor, I'm just reiterating a little bit of what the doctor has said because I want to lock him into his testimony. Why? Because I have testimony, I have a transcript showing that he's done something and said something totally different. So now we continue the cross-examination. Doctor, isn't it true that 2 years ago you gave testimony in the case of Jones versus McGillicuddy? Yes. And you recall that case? No, I don't. You recall you gave testimony in that case in New York County? No. Okay, doctor, you recall, let me refresh your memory. That case involved the failure to timely diagnose and treat a bowel perforation during the course of the procedure? Oh, now I remember. And you recall, doctor, that that procedure was identical to the type of procedure that was done in this case, correct? And doctor, in that particular case, you were called as the plaintiff's expert, as the injured victim's expert witness, correct? Yes. And in fact, in that particular case, you were advocating on behalf of the injured victim. True? Yes. And in that particular testimony, doctor, you were asked this question and gave this answer. Isn't it true, doctor, that the failure to timely diagnose and recognize a bowel perforation during the course of surgery represents a departure from good and accepted medical care? Answer, yes. Were you asked that question and did you give that answer? Well, I guess so. You guess so? Doctor, I'm showing you the transcript. This is the testimony that was given in this case on January 22nd, 2010. And that's a very powerful message to show to the jury that here's an expert who now has testified in a totally different way in a similar circumstance. And that's a great way to get out a message saying that the doctor or whatever witness is on the stand has now lied or has contradicted themselves. Now, after you show the contradiction, you don't do the touchdown dance saying, yes, I got it, because that's totally unprofessional. The jury sees it, they recognize it, and then you drop it and you leave it alone and move on and ask other questions. And during the course of closing argument, that's when you turn to the jury, and that's when you make a big deal about it. Because now the witness can't answer you back, and now you go ahead and explain to the jury the significance of that. Why do I tell you about this? I tell you about this because it's important for you to understand how these types of cases work. If you're considering bringing a possible case, and you think you might have a case, what I encourage you to do is pick up the phone and call me. I answer questions like these every single day. I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.